I remember the moment the news broke because everything shifted instantly. Within minutes of the Supreme Court's decision, the noise stopped. The talking points evaporated. The confidence that had surrounded Trump's legal strategy for months simply collapsed. You could feel it, not just in the headlines, but in the reactions of people who actually understand power and law. One voice cut through the chaos almost immediately: George Will, a conservative who doesn't chase clicks, a man who has spent decades defending institutions, not personalities. When he appeared on national television and said Trump's legal strategy was finished, not wounded, not weakened, but finished, that was the tell. When someone like Will says something is over, it usually is. This wasn't about optics anymore. It wasn't about messaging or delay tactics. The Supreme Court had just delivered a unanimous rejection of Trump's emergency request. No dissent, no hesitation, no procedural escape hatch. Even the justices Trump himself appointed declined to help him. That's when it became clear this wasn't a setback, it was an endpoint. Trump's lawyers had made one last gamble, a sweeping claim that a former president cannot be criminally prosecuted for actions taken while in office. Not limited immunity, not conditional protection, total immunity. A theory that would have placed presidents beyond the reach of criminal law forever. If it had worked, it would have rewritten American governance. But the court didn't blink. They rejected the request outright, signaling that the argument wasn't even strong enough to pause the process. In legal terms, that's devastating. It means the justices saw no serious likelihood that Trump would ever win this claim, now or later. In plain language, the shield Trump was counting on doesn't exist. What struck me wasn't just the ruling itself, but how clean it was. No fractured opinions, no ideological splits. Conservatives, liberals, Trump appointees, all saying the same thing without needing to spell it out. You are not above the law. George Will understood that immediately. He didn't celebrate, he didn't posture, he pronounced. He called the immunity argument what it always was, a legal fantasy built to delay accountability, not avoid it. And here's the part many people missed: timing. Trump's entire 2024 strategy depended on running out the clock. Delay the trials, win the election, regain control, make the cases disappear. That plan just died. With the Supreme Court refusing to intervene, the trial judge now has a clear path forward. No more pauses. No more appeals. No more procedural fog. The machinery of the justice system is moving again, and this time there's nothing left to stop it. What we're watching now isn't just the unraveling of one defense. It's the collision between a man who demands loyalty and a system that doesn't offer it. Courts don't bend. Constitutions don't negotiate. And when someone finally runs out of legal terrain, the fall isn't dramatic. It's inevitable. And this was the moment inevitability arrived. What happened next was quieter, but far more revealing. After the ruling, there was no unified Republican defense, no coordinated counterattack, no confident chorus insisting this was just another delay. Instead, there was hesitation, silence, careful language, the kind people use when they sense gravity but don't yet know how to respond. That's when you start noticing who steps back. Senior conservatives who had defended Trump for years suddenly shifted their tone, not openly abandoning him, not yet, but choosing words like process, institutions, and the rule of law, phrases that signaled distance without confrontation. The loyalty that once felt automatic began to look conditional, and that's because this ruling changed the risk calculation. For a long time, supporting Trump meant weathering controversy, not consequence. Defending him was loud, but relatively safe. But now the Supreme Court had made something unmistakably clear. The case was going to trial. Evidence would be presented. Witnesses would testify. Facts would be examined under oath. That's a different environment. In politics, you can argue narratives forever. In court, narratives collapse under cross-examination. Trump's lawyers understood this immediately, and that's where the real tension began. Publicly, they had to project confidence. They had to reassure Trump, his base, and the cameras that nothing had changed. Privately, they knew everything had changed. Their strongest argument, presidential immunity, was gone. What remained were defenses that required concessions Trump has never been willing to make, narrowing claims, avoiding absolutist language, acknowledging factual disputes, real lawyering, the kind that doesn't flatter the client. And that's the trap. Trump demands attorneys who fight, not ones who manage damage. He rewards aggression, not realism. But aggression doesn't work when judges have already rejected your core premise at every level of the judiciary. So his legal team is now forced to choose between two losing paths. They can continue feeding Trump's instincts, filing motions that play well on social media but fail in court. That keeps him happy, but worsens his position with judges who have already shown zero patience for delay tactics. Or they can pivot to a serious trial strategy, one that limits exposure, avoids grand claims, and focuses on minimizing harm. But that would require Trump to accept constraints, silence himself at times, and stop treating the case as a political rally. Anyone who knows him understands how unlikely that is. This is where the personal and the institutional collide. Trump built his power on dominating rooms, controlling narratives, and forcing loyalty. But courtrooms operate on the opposite logic. They strip away status. They reduce everyone to the same procedural footing. They don't care how many votes you got or how loud your supporters are. And that's deeply destabilizing for someone whose identity depends on exception. The Supreme Court's unanimous refusal didn't just clear the path to trial, it exposed a deeper truth. Trump's legal problems can no longer be managed the way he's managed everything else, by pressure, delay, and intimidation. Those tools don't work here, and once that becomes obvious to the people around him, donors, allies, operatives, the gravitational pull begins to weaken, not all at once, not dramatically, but steadily, because power, in the end, is about outcomes. And for the first time in years, Trump is facing a process where outcomes aren't negotiable. The fractures inside the party didn't explode. They crept. After the ruling, Republican officials started speaking in layers. Public loyalty on the surface, private anxiety underneath. You could hear it in interviews where answers became longer, more abstract, more cautious. No one wanted to be the first to say the obvious, but everyone understood it. This case was no longer hypothetical. For years, Trump had been protected by uncertainty. Would the courts really go that far? Would prosecutors blink? Would judges hesitate? That ambiguity gave cover to allies who could say, let's wait and see. The Supreme Court just removed the waiting. Now there is a trial date on the horizon, a jury, evidence, oaths, and suddenly, being tied to Trump carries a different cost. Moderate Republicans are staring at an impossible equation. Trump still dominates the base, but general elections aren't won by bases alone. They're won by independents, by voters who value stability, predictability, and competence. And nothing about a former president on trial for attempting to overturn an election feels stable. Every strategist understands the nightmare scenario. Trump wins the nomination while standing trial. Court testimony dominates the news cycle. Witnesses describe pressure campaigns, fake electors, phone calls, schemes. Even if he's not convicted before November, the damage accumulates daily. And if he is convicted, that's uncharted territory. Party leaders won't say it out loud, but they're running the scenarios. Can you campaign with a nominee appearing in court? Can you defend democracy while excusing an attempt to subvert it? Can you argue law and order while dismissing unanimous Supreme Court rulings? There are no good answers. Meanwhile, the most devoted supporters are reacting in the only way they know how: escalation. The court isn't wrong, they say. It's corrupt. The justices aren't independent. They're compromised. Even the ones Trump appointed are now traitors. That's the danger George Will warned about. When loyalty to one man overrides loyalty to institutions, every unfavorable ruling becomes illegitimate by definition. Courts stop being arbiters. They become enemies. And that logic doesn't stop at Trump, it spreads. Once people accept that judges are only legitimate when they rule your way, the entire system starts to hollow out. That's why this moment matters far beyond one defendant. The Supreme Court's decision draws a bright line. It says that elections matter, that losing an election has consequences, that attempting to cling to power through extra-constitutional means is not protected behavior. That line will shape every presidency that follows. Future presidents will know there is no magical immunity waiting for them once they leave office, no shield that turns criminal acts into political disagreements. The criminal justice system remains a backstop, not often used, but real. That changes incentives. It doesn't mean presidents will suddenly become saints, but it does mean the cost of crossing certain lines is no longer theoretical, and systems work best when consequences are credible. For Trump personally, this creates a final contradiction he can't escape. He wants to be both the victim of the system and the master of it. He wants institutions to bend for him while claiming they're illegitimate. He wants loyalty without accountability. But the law doesn't operate on loyalty. It operates on facts, and facts don't negotiate. This is why the next phase will feel different. Less noise, less spectacle, more procedure. Motions, jury selection, testimony, evidence. Slow, methodical, unforgiving. The kind of process that doesn't care who you are, only what you did. And once that process starts, there is no narrative strong enough to stop it. What comes next is the part people underestimate because it doesn't look dramatic at first. Once a trial becomes inevitable, everything slows down, and that's exactly what makes it dangerous. The spectacle fades, but the consequences deepen. Campaign cycles move fast. Courtrooms don't. They grind forward with patience and memory. Every statement is preserved. Every contradiction becomes evidence. Trump has always thrived in chaos. In moments where attention is scattered, outrage replaces analysis, and speed overwhelms scrutiny. But a criminal trial is the opposite environment. It's controlled, sequential, relentless. And that environment favors facts, not force of personality. As the calendar tightens, Trump's two worlds begin to collide. On the campaign trail, he must project strength, certainty, inevitability. In court, his lawyers must argue restraint, nuance, limitation. Those messages cannot coexist for long without tearing each other apart. Every rally speech becomes a risk. Every post becomes potential evidence. Every attack on witnesses or judges invites consequences. This is where discipline matters most, and discipline has never been his strength. Meanwhile, voters outside the base are watching something unprecedented unfold, not through partisan framing, but through repetition, court filings, judicial orders, testimony summaries. Over time, repetition does what headlines can't. It normalizes reality. A former president isn't being attacked, he's being prosecuted. That distinction matters. Independents don't need to love the justice system to respect its process. They don't need to hate Trump to question his judgment, and once doubt settles in, it rarely leaves. This is the quiet shift strategists fear most. Not outrage, indifference, the moment when swing voters stop arguing and start disengaging. When the question isn't, is this fair, but why is this happening at all? History shows that trials don't just judge defendants. They judge eras. They expose how power was exercised, how norms were tested, how systems responded. Watergate didn't end with Nixon's resignation. It reshaped how Americans viewed the presidency for a generation. This case carries the same weight because it answers a question the country has avoided for years. What happens when a president refuses to accept loss? The Supreme Court has already answered part of that question. The law still applies. Delay is not immunity. Power does not convert misconduct into privilege. Now the rest will be answered in public under oath. And that's why this moment feels different. Not louder, not angrier, more final. Trump can still campaign. He can still dominate headlines. He can still command loyalty from millions. But for the first time, none of that controls the outcome. The system is moving without him now, slowly, deliberately, irreversibly. And when systems move like that, personalities stop mattering. Only records do.